everybody, this is Dawn Black with Century 21 here. Like I promised, I'm here at almost 6 o'clock, or it is 6 o'clock. I am here with my Q&A with my special guest, the real estate attorney who will be bopping in a minute. But I just want to get some things out of the way. I just want to let you know, if you comment, if you're seeing this, please comment. Let me know that you like it. Put thumbs up. I like to get a little bit of feedback from you if you're liking what I have here and you feel that the information that I'm providing you is helpful. I'm your resource for real estate. I just want to make sure that you are getting a better understanding of the real estate transaction and any points of it. So last time so far I've had a stager on. I've also had my home inspector on, and I'm going to be bringing on my attorney here in just a little bit. So a couple things I just want to mention is that we will, in the comments below, if you do have, I did collect a bunch of questions from everybody out there, and thank you very much for participating and sending me your questions. So I do want to get through all of these questions, but if you have anything that you might have thought about that I wasn't able to get, please put it in the comments below and just make sure that, just comment down, or you can private message me, and I'll make sure that we get Steve, who's here, to answer those questions for you. So what I want to do now is I would like to introduce my guest. His name is Stephen Forte. I've known him probably for over 20 years. He is the real estate attorney that I highly recommend to all of my sellers and buyers out there. So Steve, why don't you come on in and...
Hi, Dawn.
Oh, yes.
How are you?
Thank you very much for making the time to come in here and be with me on my Facebook Live today. Like I said, it's a Q&A, so we do have a lot of questions here that we will be answering. But I would like everyone out there, I'd like you to introduce yourself and kind of give everybody a little bit of a background.
Sure. Well, thanks for inviting me. I'd like to appreciate the opportunity to talk to your clients and contacts, to educate them on this process. I know a lot of times folks don't have any contact with attorneys other than a real estate transaction, so this is a very important part of the process. I've been in the practice since 1996, so about 22 years. All of that has been in the real estate realm, along with some estate planning. Prior to that, I'd worked as a tax accountant for 5 years, and have an undergraduate degree from Indiana University in finance. Been representing buyers and sellers the whole time, and I've enjoyed the relationship that we've been able to develop and work with your clients.
Yes,
so thank you.
Yes, thank you too for being there for my clients. And I know that every situation is different. The reason I brought Steve here is because we use a multi-board residential real estate contract. It's a 6.1. And there is a paragraph on there that states that the buyer and the seller have 5 business days after the date of acceptance of a contract to get their real estate attorney to review the contract, whether they're representing the buyer or whether he's representing the seller. So what I would like to know is, or first off, let us know, you've been in the business for how long now?
22 years.
22 years, and you have a staff of people that help you out. Can you tell us a little bit about your staff?
Well, actually, this is the best staffed we've ever been. We've got 5 assistants. 2 of them are dedicated entirely to real estate. 2 others are part-time real estate and part litigation. And the 5th one does not involve the real estate at all. But we've got the 2 dedicated to real estate. Our lead assistant is Tammy Pankinen, and she is phenomenal. She's been with us a little over 3 years now. Prior to that, she had been working with title companies as a closer and as a title agent for probably 15 or 16 years with some of the top title companies in the region. So she is an absolute rock star. You'll love her. She's very personable.
She is. She's very on top of things.
Yeah.
She'll answer any question you have, and she does. She's really on the ball, and she really can settle you down too. Just answer any questions to calm you down, because buying and selling a house can be a very stressful time.
No doubt.
Yes.
And our other assistant, Gabby, is been with us a little over a year, and she's showing some great signs and is really a valued asset as well. So very fortunate. My partner is a real estate attorney as well. So we've got a fine old machine after 20 years. We've got the process now.
I was going to say, Marty is his name, right?
Marty Kujia. excellent attorney as well.
He's like, if you can't be around, he backs you up, and vice
Yep.
versa. So
Yep.
it's a complete staff here.
Yeah.
So what I would like to do is, because with buying and selling a home, can you kind of break down in a step for, like, let's just first off talk about a buyer. How do you represent a buyer when I give you it's attorney review period, I'm giving you the contract, and I'm
Right.
asking you to represent this buyer? How do you?
So you've done all the heavy lifting.
Yes,
You've shown
See my muscles?
you've shown maybe 50 properties to people. They finally, you wore them down. They
Yes,
finally go ahead
yes.
and buy, and the contract makes its way over to me. And at that point, there'll be an initial contact by me, and we'll just reach out to them. I want to let you know we received the contract from Dawn. We're getting the file set up. I'll be calling you back. So within a day or so, or two, maybe depending on what how the schedule is like, we'll reach back out to them and we'll go over the transaction. What are the specifics? What are the details? What can they expect? And the process really centers initially around calendaring certain events. There's 3 big contingencies that we typically deal with from the buy side. The first one is the attorney review period, where we have a 5 business day window for both the buyer and the seller to review the contract with their client and propose modifications.
And that's after the acceptance, so that you're
That
counting
clock does not tick
until
until
after
after
it's signed
accept.
and
So
dated.
if you signed it on the 15th, the next business day is day 1.
Yeah.
Okay? So not including weekends and federal holidays. The second major contingency or hurdle that we have to overcome is typically the home inspection. It's a very critical part. I think you just had
We had home team at Milky was on. We talked about the details on how he does his home inspection, and he puts together that report. And when we receive that report, we hand it over to Steve, so Steve can talk to the buyer about that.
and that report is invaluable because it really gives the home buyer a true perspective of the condition of the property. And so we start to go through that, and I really rely on that report because, in law school they didn't teach us plumbing or electricity or how to repair
So
a
you're
foundation
saying
crack.
you're not a handy guy.
Well, I'm actually pretty handy, but I'm certainly not qualified to give anyone else advice on that. So we'll go through that very exhaustively, go through each one of those items that's enumerated to see whether or not that's a real concern for the buyer. So some buyers are quite handy, others, they just not going to be able to do it. So we put the list together of, do we want a repair request? Do we want to ask for a credit? Perhaps a home warranty is appropriate to cover some aged appliances or furnace or water heater, things like that. And then I try to set expectations as to what typically takes place in that negotiation. And so each buyer has a different set of demands. They may feel like they're just not willing to accept the condition of the property is drastically different than what they considered it to be in at the time they made the offer, or the opposite could be true. Boy, it's in a lot better shape than we thought, and we're feeling pretty good about it. We just don't want to rock the boat. We'll ask for 1 or 2 things. And so we work through that process. We put a letter together. We put out the request, and we help them negotiate that those home inspection issues to a conclusion. The third major hurdle is the mortgage contingency. So we've agreed on terms. We've come to agreement on the home inspection items, and now we have to get that financing, unless it's a cash buyer. So if it's a cash buyer, this doesn't apply, but that's usually
Doesn't happen quite as
no,
often
maybe
as
that's
we would like.
10 or 20% of
yes,
the transactions.
yeah.
The majority are going to have a financing contingency, and in that time frame, we're having an appraisal, and we're providing the buyers are providing
Yes.
the lender with all the necessary documentation, tax returns, W-2s, bank statements, all the financial data that the lender's going to need to complete the underwriting process. And so there's a timeline on when that has to be completed by. And if you don't get an approval from the lender within that timeline, we have to either say, sorry, we couldn't get the loan and cancel the deal, at which point you can get your earnest money back, or we have to ask for an extension. And most sellers are willing to grant that extension at least the first time without much pushback. Ask for it second or third time, it starts to get a little less certain.
And that would be like we call it the clear to close date, right?
Yes,
so
clear to
because
close date.
that means they've gone through, and we can get a lender out here to get into specifics of financing, but it just basically says that they have their loan in place, and the next step would be setting up the closing, pretty much, right?
That's right. We don't schedule the closing until we have that magical clear to close letter.
Now, do you, on a buyer's side, do you schedule the closing?
So once we have the clear to close, we'll reach out to the other attorney and let them know.
The seller side.
Yeah, the seller side. Let them know that we've received the clear to close and we're ready to schedule.
Okay, all right.
Yeah.
So is that everything? Is that pretty much everything that you do for a buyer?
Well, no, not at all. One of the major things that we do is we make sure that you're being conveyed title, free and clear of any liens or judgments or encumbrances of any type. We most importantly want to know that the person you're buying the house from actually has the right to sell it to you.
Right.
So reviewing the title commitment is critical. If it's a single family home or a townhome, we're going to receive a plat of survey. We'll make sure that there's no building line encroachments, that there's no setback violations, there's no easements that are going to get in the way. There's some pretty critical things that take place. We look at well and septic tests. If you're out in the collar counties, that pops up. You may have a home sale contingency. You may say, I want to buy this house, but I can only do it if I sell my other one.
Right.
So we're monitoring that and making sure that the other transaction is progressing within the time frame and the deadlines so that we're protecting your earnest money at all times.
Okay.
So there's a lot that goes on,
there's
more than what
probably-
we're going to be able to talk about.
Right,
now.
exactly. I mean, but the thing is you know that Steve's looking out for your best interest, and he's going to follow through the contract. I mean, we're not going to go through the contract. That could be another talk to kind of go through the specifics of the contract. But let's talk about what do you do on the seller's end. Just give a couple points on how you handle representing a seller.
So the initial conversation is quite similar. Once we receive the contract, we're reviewing it with the seller, letting them know what to expect next. So we may have some attorney modifications that we want to make to the contracts and changes of the language. We may receive an inspection report with requests attached to it, and so we'll discuss those with the seller to see whether or not they're willing to make the requested repair, whether they want to offer them money in lieu of a repair, or whether they want to decline entirely, to respectfully decline to make any repair based on that price. They feel that they can't make it, or perhaps they just don't have the money to complete the repair, and they're not able to do it. So we work through that process of negotiating a home inspection and attorney reviews. We do also need to order title. We've got to be able, as I just mentioned, the buyer needs to know that you have the right to sell the property. So we do have to provide them with evidence of clear title, and that involves hiring a title company to conduct a title search. Now, you have the freedom to pick any title company that you choose. The majority of them are all within the same range as far as fees go. They base it off of the sales price because it's an insurance. It's insurance. The risk is correlated to the sales price. So obviously, the insurance on a $400,000 home is less than the insurance on a $100,000 home. And so the seller is free to choose the company of their liking. Generally, I've got one or two that I like to stick with and that I'll recommend, because if an issue does come up, if there's an old lien that wasn't released, perhaps you refinanced 15 years ago and the lender never recorded a release, it's going to affect your ability to convey the property to the buyer. And in those situations, I like to have the resources in place with the title companies I've worked with over the years to be able to get that resolved so that we can do what you want to do, which is sell your home and move on.
So do you also order the survey on that?
Yes. So yeah, along with the title search, we have to order a plat of survey for single family homes and for townhomes, and we'll take care of that. We order the payoff. So if you've got a first lien or a home equity line or any other bill that needs to be paid, if there's a judgment or a tax that's due, we go ahead and take care of finalizing what that figure is and how we're going to get them paid after closing out of the proceeds. If there's a well and septic, we order the tests for both the well and the septic. We get the water tested with the county. In some jurisdictions, there are what is called a transfer stamp. So for example, we're in Schaumburg right now. Schaumburg charges $1 per thousand of sales price.
I think it's the cheapest one around, really, as far as
Yeah, I mean,
transport
well,
fees.
some charge, like for example, Palatine doesn't have it, but Hoffman Estates charges $3 per thousand.
Yeah.
Schaumburg's $1 per thousand, and if you're over 65, you don't have to pay it.
Yeah.
So that we help you, we take care of all the paperwork for that and help you navigate through paying the final water bill and getting the stamp, and so that we're able to complete the transaction.
So needless to say, there is a lot of things that happen when you're selling a home, too, that have to be taken care of. And two, you had mentioned also if there's an association or if it's a condominium,
Yes, absolutely.
you have to get you order the rules, regulations, bylaws, 22.1, everything that goes together.
Yeah,
with that.
so that's really critical because when you have a homeowners association, the buyer wants to know certain information. They want to know, one, that the dues are current, and that's called a paid assessment letter, and that the association's waiving what's called their right of first refusal. So they're accepting you as a buyer, and they're telling you how much is owed by the seller. So that's really important. So the seller has to provide that. Buyer wants to see that. The second thing generally is what's called a 22.1 disclosure, and that refers to a provision in the Illinois Condominium Act. And in that act, it says that the seller shall provide, and it's got a litany of things that they're going to provide. But typically, it's financial information. Well, and it's the governing documents. It's the rules, the regulations, the declarations, the bylaws. It's going to be budgets, and it's going to be information about financial condition. What are the reserves that the association has? Are they implementing any special assessment? Do they anticipate any big capital expenditures in the coming, in the near future? So if the whole association has a new roof that's going to be put on, is that buyer walking into a bill of $7,000, $8,000, $10,000? Well, they'd like to know that. Is the association involved in litigation? We have some associations that have been in litigation for years, and the buyer needs to know that there's some risk that they're walking into. If that litigation is not resolved in favor of the association, there could be potentially a special assessment levied against the buyers.
Is it too that if there is a litigation going on, that sometimes it's hard for a buyer to get a mortgage on a home?
Yes.
Yeah.
So generally in those, we kind of know which ones those are, having dealt with so many of them in the area for a long time. We reach out to the attorney handling the litigation, and we get an updated letter from them stating what the status of it is, whether it's being defended by the insurance company of the association, what the coverage is, what the anticipated settlement is, and how far along in the litigation it is. And generally we can get the lender to give them a comfort level that.
So they'll go ahead through with the
Yeah, but
financing.
not all of the time. Sometimes we have to shift. So sometimes the association will say, we've had a lot of luck using buyers who have used lender XYZ, and we recommend that you go that route. So that's really valuable information.
All right. Well, who's out there? Denise, I want to say hello to you because you said hello back. So hello. And Charles, you're out there too. I'm glad you guys are out there listening. I think what we're going to do is we're going to start with the questions that everybody had put together for us, and I kind of put them all on a Q&A format, so we're going to go through, and if you don't mind, I'm just going to give you the questions, and you got to answer.
I got it.
So,
I'm going to knock them out of the park.
Right.
Let's go.
Okay. It says, do you disclose in advance what your charges are for title fees? Do you disclose?
Well, so actually, the title fees, they're not my fees. They are generated, as I mentioned, off of a fee schedule. And when Chicago Title issues their title charges, pretty much all the title companies in the area follow suit, or they're in the same range. There might be a few dollars here and there, but generally, the fees are pretty similar throughout the industry. You can find a title company here and there that's going to be a little bit lower. I generally stay away from them because, as I mentioned, to me it's so critical that if an issue pops up, I need the ability to clear that title for you in a timely manner and not be held up because we can't get a hold harmless letter because of an issue that happened 15, 20 years ago, a divorce, a Liz pendants that was filed from a contractor that you had a dispute with, a refinance that occurred multiple times. Maybe you refinanced 3 times ago and that lien is still on there, and it can be a real problem. Maybe there was a tax lien that somebody had the same name as you, but it's attached to your property.
Oh, wow.
So Yes, there's I don't charge the fee. The fee is whatever the title company says it's going to be. As an attorney, though, we are title agents, and we do some work for the title company, and the title company does compensate us for that.
The
work.
next question says, are you closely associated with the title company and being financially rewarded for using them versus other clients' company and rate choices?
So we are affiliated with our title agents for probably 5 or 6 different title insurance companies. So if you have a preference, usually we can accommodate that. And the fee that you pay the title company is independent of whether I'm an agent for that company or not.
Okay.
They don't charge you any less because the work has to be done. Is the work going to be done by the attorney, or is the work going to be done by the attorney at the title company? They don't really care who does the work. It's the same fee irrespective of who does that work.
Okay. Does the buyer have the right to choose a title company in order to compare fees?
The buyer does have the ability to choose the title company for the lender's title insurance. There's 2 types of title insurance. There's an owner's policy that the seller is responsible for providing to the buyer, saying that the property is owned free and clear, and they have all the rights, title, and interest and the ability to convey it without any liens or judgments or encumbrances. The seller is going to order that seller's policy, and typically the lender's, almost entirely, the lender's policy is going to come from that same title company. And the buyer could break off their portion. It's called bifurcating title. It never works smoothly. It's a disaster. I highly discourage it.
Okay. When do you have to turn in? When do you have to turn in the earnest money?
Well, you can put in the contract when you want to turn it in. We're turning it in as we make this offer. We're turning it in 5 days after we agree on attorney review and home inspection items. We may not have earnest money. So it's going to be up to the parties to agree on when that earnest money is going to be provided.
The chances of it not having earnest money are pretty slim. I think somebody,
Sure.
there, you always want to see some earnest
Absolutely.
money.
Every seller wants to see that you're serious about it. And it's kind of changed over the years. When I first started, it would be 5 or 10% of the purchase price. Then it was down to 3%,
No, I think
2%.
it's 1%.
Now it's a lot of times it's just $1,000.
Yeah.
So yeah, it's come down over the years, and I don't really see it being much of an issue. Sometimes you have to track down a copy of the check.
Yeah.
But usually it's not an issue.
And when is the cutoff before you lose that money?
Well, so the earnest money is available to be returned to the buyer under certain conditions. If we can't reach agreement on those attorney review items, we've got 5 business days to raise them and another 5 business days to solidify, come to an agreement. After that 10 business day window, if we can't, if we're in default after that, we're going to lose it. We've got the home inspection provision. Again, 5 business days to raise it, 5 business days to negotiate agreement. Now we can extend either of those deadlines, but if we want to cancel it under the home inspection provision outside of that 10 business day window, and we try to cancel it on day 11, well, we can't get that earnest money back unless you've got an attorney that's got that deadline calendared and extends it out on your behalf and says, we want to continue to negotiate past the 10-day period, and the seller agrees to that, then that earnest money is protected. And same thing with the financing. You've got a deadline. You'll have financing in place by November 15th. November 15th comes, you don't have it, and you didn't extend the deadline, and you don't get and the mortgage doesn't come through, you're not getting that earnest money back.
Unless they extend you.
You didn't get the extension, and you didn't get the clear to close.
Okay. All right. In outside area, attorneys are not used in real estate transactions for closings. Why do we use a real estate attorney in Cook and DuPage counties, and when are they rarely used elsewhere?
Oh, so I never really understood this. And actually, Cook, DuPage, McHenry, Lake, Will County, we all use it. Every attorneys in all those. I'm going down to Joliet tomorrow. I was up in Antioch last week. We're all over the place. Down in the Loop, out to Rockford. But I never quite understood the other jurisdictions that don't use the attorneys, because we're the cheapest guy at the table. My fee is $475, and we're there to protect your interests. And so what do you do? I always was curious, what happens when it comes time where legal advice is required? Is the realtor providing legal advice? Is the lender providing legal advice? Is the title company providing legal advice? And how good is their legal advice when they're not lawyers?
And I'm telling you, I've been in a situation where my client didn't want to have an attorney, and I can't act as an attorney.
No.
I mean, I'm not an attorney. I can't act as an attorney. And basically, what happens is that client of mine has to represent themselves.
Yeah.
You know, which
And,
can be a real...
right, you don't want to get tagged with the unauthorized
No.
practice of law.
No,
And
no.
and it really just doesn't help your client. There's so many issues that come up. When we're reconciling the financials, the numbers a lot of times are off. The tax prorations can be tricky to calculate, and you have to know whether or not there's a senior exemption or senior freeze. And then there's all the negotiation of the attorney modifications, the language itself, the modifications to the home inspection items, as we discussed, the deadlines and the ramifications of missing those deadlines for the mortgage contingency. I know most people don't know how to read a survey. How about the title commitment itself? How do you know you're getting clean title?
Yeah, right. I've never seen them.
I know that people do it. I
You're
can't
the
imagine.
guys
I can't imagine making the biggest purchase of your life and not having somebody there to help you out.
No, not at all.
And that's
Not
what
at
we
all.
do. I mean, we're really, our job is to help people.
Right.
We
Right.
advocate for their position and we help them.
Exactly. The question, if you have a pre-listing inspection, and this is interesting, if you have a pre-listing, so some of those sellers go out, they have an inspection done on their home, okay, and items are brought up before the home goes on the market, okay, what items would have to be disclosed, okay, besides radon? I mean, because because it says in the disclosure, we have a seller's disclosure, we have the lead-based paint disclosure, we also have the
Mold disclosure.
Well, they don't use the mold disclosure that much. They mostly use the radon, the lead-based paint, and the seller's disclosure.
The real property disclosure.
Exactly.
So that real property disclosure, I think it's got 26 or 27 items.
Yeah, 23.
And
23
the most
items.
recently added one, I think, has the property ever been used for the production
yes.
of methamphetamines. So if you have a meth lab, then you got to disclose it.
Okay.
But no, really, the purpose of that is to disclose what are called latent defects. Defects that you know about as the seller, but it'd be really hard for the buyer to discover.
Okay.
You know,
So you're saying if you're having a licensed inspector come and do that, it's a pre-listing inspection to tell you what's wrong with the home. Let's say they tell you that there's, your electrical is not wired correctly. Are you bounded now because you're the seller selling the house and you're filling out that disclosure? Do you have to disclose now that wire, if you don't fix it, that's not wired correctly?
You have to if you know it to be a safety hazard, you need to disclose it.
Okay. So that would be yes.
And my advice to clients is over disclose. You can never get in trouble for disclosing too much. But if you don't
Honesty
disclose,
is the best policy.
if you don't disclose, it can come back to hurt
Yeah.
you really bad. And not only that, if it is a safety issue, nobody would want to. The unthinkable could happen, and that would just be, you'd
That'd be awful.
be regretting that for a lifetime.
Oh, definitely. So, why do sellers' attorneys wait until the very last minute to order the title when they know that if there are problems, it will delay the closing?
Well done. In my office, you're using the wrong attorney. In my office, when we set the file up, when we're writing down the phone numbers and contact information for our clients, as soon as that file is set up, before it even comes to me, the title order is placed.
Okay.
So
all
we
right.
order
So
it right away.
Wait. You don't wait.
We don't
till
wait.
last minute.
No. We want, and that's really critical to keep the loan process going. The lender needs to see what's called a title commitment and a title invoice because they've got to disclose what the numbers are going to be, what the bottom line for the buyer is going to be, so that they can determine whether their ratios and are going to be satisfied and whether they're going to be able to underwrite that client. So it's critical that the buyer's lender has those figures right away. So we order that right away. That's part of our intake. Yeah.
Right here, he orders it right away. It says this question is from so this is an outside of state realtor that is asking this question. So let us know if you can answer it. It says if a seller refuses to do any repairs, or concessions after health or safety issues have been brought up that needed to be corrected, that are from an inspection, is there any way for the buyer to get a seller to reimburse them for the inspection costs if they terminate the agreement? So they want to get reimbursed on the inspection cost.
So that's I can only speak for Illinois, and in Illinois, the inspection fee would not be reimbursable. That's in the contract that we use anyway here in this area, the 6.1 multi-board 6.1. And some of the other contracts that are in the area, they do not allow for a refund of the cost of the inspection due to disclosure of health or safety issues, or really any issue. That's the whole point of the contingency, the home inspection contingency, is to allow the buyer the opportunity to conduct their due diligence to determine the condition of the property. And if you found out that it had some really real concerns, some safety issues, probably the best money you're going to spend.
Yes,
you didn't buy
definitely.
a house that was going to be a lifetime of problems.
Exactly. Can I back out of a contract any time before closing is the next question, and are there penalties if I do?
Well, you can't back out at any time. There are some times that you can back out, and it has to be for cause, because every contract has what's called a covenant of implied good faith. So both parties have to act in good faith. You can't just turn around and cancel the contract and expect that there won't be any financial ramifications unless you do within the confines of the contingencies. Was it if we didn't reach agreement on terms, if we didn't reach an agreement on inspection issues, if we weren't able to get the loan, if the well wasn't producing the water that it should have, if we couldn't sell our other home.
Yeah.
There are reasons, legitimate reasons to get out of a deal, but if you just changed your mind or found a better house and you cancel it outside of those contingencies, then you could have not only lose your earnest money, but you could be subject to litigation where now the seller isn't able to sell the house till next spring, and the market's changed, and they lost $40,000 on the next
And
sales price.
Time.
A lot of marketing time, and they maybe had consequential damages. You could be in for a lot more than the earnest money because you backed out without just cause.
Do I have to be, and maybe you take it from both sides, do I have to be present for the closing?
Well, certainly as a buyer you do. You're going to be required to sign the lender's documents. On the sale side, generally, most sellers won't go to the closing. They'll pre-sign. They'll come into the office. We'll sit down. We'll go over all the documents, reconcile the financials, and have them pre-sign and give me power of attorney to sign the closing statement, so that they don't have to sit there for 2 hours and watch other people sign paperwork on the day that they're moving.
Is there a charge for you to act as power of attorney for the seller?
No.
Okay. And this question says, what is your fee?
As I mentioned, it's a flat fee. It's $475. Whether it's a buy or a sell, it's the same price. I do not require a retainer, especially coming from Dawn. We've worked together so long. I know that her clients are pretty well.
Good people.
Yeah, they're good people. They know the routine. They know what to expect. And occasionally, what will happen is we end up canceling a deal for one reason or another.
The next question.
And if that does happen, I just charge them a flat fee of $150 with the expectation that they're going to buy another house or they're going to sell that house, and we'll have a second chance to work together.
Yeah.
So yeah.
Well, and then another thing is, how soon do I need to hire an attorney, before or after I sign the contract?
Because of the attorney review contingency contained in the contract, most folks, you're fine not consulting with the attorney until after the deal is been accepted. But certainly, it doesn't hurt if you've got particular questions or concerns that you have in your transaction. A lot of times there's unique situations. Sometimes it's an estate sale. Maybe it's a short sale. Maybe you're buying from a bank or from a short seller.
Right, I was just going to say a bank owned.
And there are, those are some kind of unique situations that you probably do want to touch base with me or an attorney.
Yeah, but there's a lot of addendums that you sign.
Yep.
So.
Yep. But if it's a traditional transaction, I would say lean on Dawn. She'll know whether you need to speak to me or not.
And I'll definitely push him his way if there's anything I can't answer. So, can I, not that you want to hear this, can I fire my attorney partway through if I don't like the home? That's an interesting one. So,
Well,
yeah.
absolutely,
Yeah.
absolutely. You know, we're working for you, and we work at your whim. And if you're not comfortable with the representation you're getting, you should fire us. We terminate the engagement and get the representation that you feel is going to protect you best.
This goes along with that question. Will that delay the closing?
It's possible. It shouldn't be by much. And the few times that I've been brought in the middle of a transaction because it just didn't work out for one reason or another. You know, typically we can pick the ball up pretty quick and not really skip a beat. Now there could be on the sales side, there could be if there was title issues that weren't getting cleared, and then we've got to jump in and try to resolve those. You know, that may push the timeline back a little bit, but it shouldn't be significant.
Okay, good. If I have made an offer on a house and the seller accepted my offer, can the seller accept a higher offer?
Well, it depends. We're attorneys, we love to say that, right?
Yeah, it depends. Yeah, sure, maybe.
So in that 5-day attorney review period, it says that we have the ability to modify terms other than sales price. So if you've got an offer, let's say the contract says this house is supposed to sell for $300,000, and another offer comes in for $320,000 and it's cash instead of a mortgage contingency, boy, you'd love to take that. But there has to be other reasons to cancel the contract, not just because of the price wasn't sufficient after you discussed it with your realtor. Now, where you will see that happen is, this might be getting a little bit too deep into the details, but if you have if the buyer has a home sale contingency, that provision allows the seller to continue to market the property, and if they get a bona fide offer, they can go that they like better than the first offer, they can go to the first buyer and say, I got this better offer. I really want to accept it. If you want me to continue with you, you have to drop your home sale contingency, which means that first buyer has to be willing to buy your house, irrespective of whether or not they sell their other house. Now, most buyers just aren't willing to take that risk. So,
do they have to? Does that first buyer have to come up to whatever? I mean,
no, they don't have to. They don't have to match the offer. They just have to waive their contingency.
Okay.
And typically, when you waive that contingency, you've got 48 hours to decide whether you want to waive it.
Okay.
And if you do waive it, you usually have to put up additional earnest money.
Usually they ask. I had some. It all depends on if it's put in the contract, but I'm sure that you do.
As an
ask
attorney,
for
when I'm on the
yes.
sell side and I see that, I
That's the
always
first thing.
force the buyer to put up additional earnest money if they
Okay.
waive that.
You want to see a little bit more of a commitment there. The other question I have is the cost for a real estate attorney. I think that you said that you had mentioned that was a $475 fee.
Yeah,
correct?
it's a flat fee. I mean, and the cost for a real estate attorney, it's just like anything. I mean, you're going to find a low cost provider. There's some guy out there that I'm sure will do it for $100, but good luck trying to reach him, and hopefully nothing will come up that's complicated and require any real legal service. And of course, there's people that are going to charge hourly. Now, the hourly.
I was going to say that was the next. Is there a fee hourly? Is it hourly or is it a fixed rate?
Well, for me, it's a fixed rate. There are attorneys that will charge hourly. Generally, the hourly-based attorneys are people that aren't really real estate attorneys. They do some real estate, but they mostly are involved in an hourly practice for litigation, and so you do run across those.
Now, I think we answered this before. What does it include? But I think we answered that in the beginning when we kind of broke down what Steve does for a buyer and then what Steve does for a seller, and that's in the beginning of this. Here's interesting. This is interesting. Now we're talking about buyers and sellers here. Who pays the closing costs?
Well, the buyer pays the buyer's closing costs, and the seller pays the seller's closing costs.
Now, but there are some instances where the buyer may ask the seller to pay their closing costs.
Well, they do that in the form of a credit. So they may say this. You see this a lot with an FHA buyer, where they just don't have enough money saved up to put towards the purchase of the property. So what will happen is they'll ask the seller, they'll agree on a price, but they'll ask the seller to give them some money back in the form of what's called a closing cost credit. And that will help cover their lender's fees, their title fees, and whatever other ancillary charges that they have.
Do I get an inspection before or after I sign the contract?
Um, so from a buy side, you would never want to conduct an inspection prior to knowing that the seller actually wants to sell it to you.
Right.
So, and I doubt you'd get the seller to let you in the house.
Yeah, exactly.
So yeah, certainly it's going to be after the contract is signed. And the seller, you mentioned a pre-listing inspection.
Yes.
Those can be valuable because if the pre-listing inspection shows that there's 10 items that need addressing, well, it's best to get those. If you're going to tackle them anyway, take care of them now, and so it makes your house that much more appealing when you sell it.
Exactly. And then too, could you, if you have that inspection, can you give that to the buyer as?
You can. So often, a lot of times the buyer, if they can visually see that the house is in good condition, or maybe they're in the trades and they feel pretty comfortable about inspecting it themselves, they may say, have you done an inspection? If you're willing to provide that to us, we won't do our own inspection, which can be great for both parties. The buyer saves, $400 or $500, and the seller knows exactly what the concerns are going to be.
Now here's an interesting one. Now, if it's because in the contract, and tell me if I'm wrong, in the contract it states that if you're going to be doing if the buyer's inspection is the cost of the buyer has to pay for that inspection. Yes. But it has to be with a licensed
professional
home inspector. Yeah. What if, and I just had this happen, what if a contractor, you find out they wanted to see the house, all of a sudden we found out that it was a contractor looking at the house. Maybe found some things that weren't in his eyes that needed to be corrected. If they come back with a contractor, not a home inspector, is that pretty much, they can't really do that? I mean,
as the seller, you've got a couple of options. You can, first of all, you can say, sorry, that's not within the inspection, the parameters of the inspection contingency. Right. It has to be done by a licensed professional. And unfortunately, this was not by my license, so we're not going to entertain that. You can take that, as a seller, you can take that position. In practical terms, though, if that buyer wants out, they're probably going to find another way to get out. They're going to disagree on the attorney modifications, and so they'll get out. You're best off saying, this is not done by a licensed contractor, but as a gesture of good faith, we're going to go part of the way. Okay. And if that's the appropriate response. But I wouldn't just dismiss it out handily unless you really are convinced that this buyer is going to buy the house.
And depending on what they bring up, too.
Right.
I mean,
right. If it's you need GFC outlets in the kitchen, they're $15 a piece. Keep the buyer happy.
Yeah, just go ahead and
just make sure, you want to keep the big picture in front of you. The goal is to sell the home.
Right.
And yeah, you might be right legally, but is that going to, saving $100 on GFI outlets, is that really what you want to do?
That's a good point. As a buyer, should I sign a sales contract without a mortgage contingency?
Only if you're a cash buyer. Otherwise, you're absolutely crazy.
And I know when I'm working with a buyer, or I first meet my buyers, I want to make sure that they have either a pre-approval letter, that they've got their mortgage in place, or if they're a cash buyer, they would need to show me that they have the proof of funds in an account.
In their name.
Yeah. Oh, yeah, you're right. In their name. And also too, so here's another thing. If let's say their parents are buying the house for them. Okay. But they want their kid to own the home. So could that be, does that mean because you're getting the money from the parents that...
Who signed the contract?
So it doesn't matter where the money's coming from?
If you want to put mom and dad and daughter on the contract, and mom and dad's account, I'm fine with that.
So it's whoever signs the contract owns the home irregardless of where the money is coming from?
No, whoever signed the contract is who's going to go on title.
Okay.
But if it's a cash transaction, how do I know that mom and dad aren't going to change their mind?
Okay, right. Okay, so you want them on the...
I want them on the hook. So if there's a default, I'm going after mom and dad because I know they got money.
Oh. Well, isn't that a pleasant thought? I better not have that happen to me. Don't worry, I'm not buying buying any houses for my kids.
Okay.
I think we've pretty much covered all of the questions here. I don't know. Hey, Kevin, I'm glad you're watching. If there's any questions that you can think of or that maybe we didn't touch upon, I think we've pretty much gone over everything that we could go over. So definitely, if there's anything that maybe we missed that you want to ask, you can always mention it in the comments below. You can also private message me, or better yet, Steve, why don't you give your contact information so
Sure.
that if there's somebody that has a question about real estate or anything, that they can contact you direct.
I'll be glad to talk with you. My phone number at the office is 847-428-9800, or you can send me an email. My email address is Steven, Steven, at kugiaandforte.com, spelled KUGIAANDFORTE.com.
Okay, so I just want to let everybody know that this recording of this Facebook Live with Steven, the real estate attorney, will be posted I will have it on my business page. I will also post it on LinkedIn, YouTube channel, and I will put it underneath the tab on my website of all the videos that I have accumulated over the last couple of years that I've done. So you'll be able to review them and kind of go back at them to review all the videos that I have made. And that's at my DawnBlockHomes.com. That's my website. Or you can go to ServingSchaumburg.com. I also, either way, you'll get to my website from those web addresses. Again, if there's any questions, please feel free to put them down. Also, I am planning on for next month, because I always like to keep new things coming in. And also, if anybody has any ideas of people, or even if you want me to get a plumber on, or if there's somebody that you want to have talk about anything, just put it out there. I'd be happy to get that person for you. I know that I will be getting an appraiser on for the month of November, so I'll be posting out a little question out there to see if you have any questions regarding appraisals that we can we can throw towards her. So that's it for now. I think we pretty much have talked about everything that we can talk about legally, and I know Steve wants to go home, and so do I. So thanks again, everybody. Have a great evening, and be on the lookout. I'm your resource for real estate, and I'll look forward to talking with you. So if you're looking to buy or sell a home, please give me a call. The number is 847-630-2121. And again, Steve, give your number and your contact information.
847-428-9800. And my email is Steven with a V, STEVEN, at kugiaandforte.com, KUGIAANDFORTE.com.
Okay.
Thank you, Dawn.
Yeah, thank you.
It.
Thank you for coming.
All right.
Thanks again, guys, for listening in. Have a great evening.